Good afternoon, ladies and gentlemen. Welcome to the IP Roundtable organized by the Hong Kong Trade Development Council and the Hong Kong Reprographic Rights Licensing Society, and sponsored by Creative Industries, the Cultural and Creative Industries Development Agency, on the occasion of the HKTDC Hong Kong Book Fair 2024. 各位来宾，欢迎大家出席由香港贸易发展局及香港书刊版权授权协会举办、文创产业发展处赞助的 IP 圆桌会议。To begin the session this morning, may I now invite Ms. Jenny Koo, Assistant Executive Director of Hong Kong Trade Development Council, to come on stage to deliver the welcome remarks. Ms. Koo, please.
Mr. Ponchbun, Dr. Sharon Wong, distinguished guests, good afternoon. A warm welcome to the first IP Roundtable of the Hong Kong Book Fair. Since the inaugural Hong Kong Book Fair in 1990, the Hong Kong Trade Development Council, as the organizer, and the other supporting organizations and partners have put in great effort to develop the fair to be an efficient and effective platform for promoting the publishing industry. And over the years, the fair has become an annual celebration of reading, and with many new titles being released during the book fair. And Hong Kong Book Fair is now a must-attend event for book lovers, not only from Hong Kong, but also in the region. And at a time when it is very vital to remind the world of Hong Kong's strengths and business advantages, the Hong Kong Book Fair is a powerful storytelling platform. And with China's 14th five-year plan, Hong Kong is positioned as the East meets West Center for international cultural exchange, as well as regional intellectual property trading center. So providing new impetus for sustaining our competitiveness and economic growth. And this year, the Hong Kong Book Fair is stepping up our effort to promote IP trading by joining hands with the Hong Kong Reprographic Rights Licensing Society to launch this IP Roundtable. Under the theme AI, Copyright, and Collective Licensing in the Asia-Pacific region, 6 experts will discuss how the governments reassess the policy and legislative frameworks in response to the rapid development and application of AI, and explore opportunities and challenges these changes will impose to the publishing ecosystem. I would like to thank our distinguished speakers and Hong Kong RRLS for supporting this event. Also thanks to the government of the Hong Kong's SAR's Cultural and Creative Industries Development Agency for the funding support to both the IP Roundtable and also the International Publishing Forum, which was just held this morning. This is the place where we could build trustful connections, gather first-hand intelligence, and the markets and latest industry trends, and underpins enduring business relationships. We hope this IP Roundtable could further strengthen Hong Kong's link with the regional and global players in the publishing industry, and to jointly explore new business opportunities through the Hong Kong platform. I wish you all the best for business, and for those of you who have traveled from afar, an enjoyable stay in Hong Kong, and hope you will help spread the Hong Kong story when you are back home. Thank you.
Thank you, Ms. Koo. Please be seated. Next, may I invite Dr. Sharon Wong, Executive Director of Hong Kong Reprographic Rights Licensing Society, to come on stage to deliver an opening remarks. Dr. Wong, please.
Honorable guests, Ms. Koo, Mr. Poon, ladies and gentlemen, good afternoon. On behalf of the Hong Kong Reprographic Rights Licensing Society, I'm honored to welcome you all to the IP Roundtable at the 2024 Hong Kong Book Fair. This event is hosted by the Hong Kong Trade Development Council and co-organized by the Hong Kong Reprographic Rights Licensing Society. Our society was established in 1995 by Hong Kong authors and publishers. It is one of the 6 licensing bodies registered with the Hong Kong Intellectual Property Department. Moreover, through its affiliation with the International Federation of Reproduction Rights Organization, IFRO, we represent millions of publications in Hong Kong and overseas. Our mission is to protect intellectual property rights of our represented authors and publishers and to raise public awareness of copyright and collective management organizations. Positioned as a regional IP trading hub, under the 14th Five-Year National Plan, Hong Kong provides an excellent platform for its IP Roundtable. This event will not only highlight the importance of IP rights, but also showcase Hong Kong potential in leading the discourse in the creative industries. Thank you all for being here, and I hope you find the session informative and engaging. Thank you.
Thank you, Dr. Wong. Please be seated. As a token of appreciation, we will now have a souvenir presentation for our guests. May I first invite Mr. Poon Chi Wah Ponch, Chairman of Hong Kong Reprographic Rights Licensing Society, to come on stage to present the souvenirs to our honorable guests. Mr. Poon, please. May I invite the following speakers to come on stage one by one to receive the souvenirs. First, may I invite Mr. Takeshi Ikkanda, Executive Director of Public Interest Incorporated Association Japan Reproduction Rights Center, to come on stage to receive the souvenir. Thank you, Mr. Ikkanda. Please be seated. May I invite Ms. Theresa Look, partner of the Intellectual Property Deacons of Hong Kong, to come on stage to receive the souvenir. Thank you, Ms. Look. Please be seated. May I invite Ms. Sarah Tran, the head of Regional Policy and Public Affairs of the International Federation of Reproduction Rights Organizations of Belgium. Ms. Tran, please. Thank you, Ms. Tran, and thank you, Mr. Poon. Please be seated. May I now invite Ms. Jenny Koo, Assistant Executive Director of Hong Kong Trade Development Council, to come on stage to present the souvenirs to our honorable guests. Ms. Koo, please. May I invite the following speakers to come on stage to receive the souvenirs one by one. First, may I invite Mr. Andrew Fong, Chief Executive Officer of Copyright Licensing and Administration Society of Singapore, to come on stage. Thank you, Mr. Fong. Please be seated. Next, may I invite Mr. Sam Irvine, Chief Executive of Copyright Licensing New Zealand. Thank you, Mr. Irvine. Please be seated. Next, may I invite Dr. Sharon Wong, Executive Director of Hong Kong Reprographic Rights Licensing Society, to come on stage to receive the souvenir. Dr. Wong, please. Thank you, Ms. Koo, and thank you, Dr. Wong. Please remain on stage. May I also invite Mr. Poon and all other speakers to come on stage again for a group photo. Let's look at the camera. Let's take a few more shots. Thank you all. Please be seated. Without further ado, the session will now begin. We are very honored to have invited Dr. Sharon Wong to moderate the session. Over to you, Dr. Wong.
Thank you. Thank you. Welcome to the IP Roundtable at the Hong Kong Book Fair 2024, and I will be your moderator for this session. Today, we are delighted to have distinguished panelists representing professional expertise in the field and key collective management organizations from different regions. Our esteemed panelists include Ms. Sarah Tran, Head of Regional Policy and Public Affairs at IFRO. Mr. Andrew Fong, CEO at Copyright Licensing and Administration Society of Singapore. And Ms. Theresa Look, Partner of Intellectual Property at Deakins Law Firm. And Ms. Samuel Irvine, Chief Executive at Copyright Licensing New Zealand. And also Mr. Takeshi Ikkanda, Executive Director at Public Interest Incorporated Association Japan Reproduction Rights Center. And we will be exploring the topic AI copyright and collective licensing in the Asia-Pacific region. As government across the Asia-Pacific region reassesses their policy and legislative framework in response to the rapid development application of AI, our panelists will explore into the opportunities and challenges that these changes pose to the creative ecosystems. Without further delay, let's begin our discussion. I would like to invite our first speaker, Ms. Sarah Tran, to begin the discussion first to share her thoughts on the topic.
Thanks so much, Sharon. Thank you. Good afternoon, everyone, and my name is Sarah Tran, and many thanks to the Hong Kong Trade Development Council and also the Hong Kong Reprographic Rights Licensing Society for having me here today. I'm delighted to be here. I hope technology works for me. Okay, so IFRO is the global umbrella organisation for collective management in the text and image sector, and we're known as RROs. The IFRO community is comprised of both publisher and author representatives, and we have over 155 member organisations across 86 countries. And together, this represents over 2 million text and image rights holders from all over the world. IFRO is deeply committed to advocating first and foremost for creators' rights and to supporting good practice and progress for collective management frameworks around the world. I won't go into too much detail here because just in the interests of time, but just to highlight that IFRO has quite a strong presence in the Asia Pacific. We have some 17 organisations that are members here in this region, drawn from 13 different countries. We offer targeted mentorship. We also offer support in terms of areas of national interest, advocacy, and also RRO best practice. I'm mindful that some of you in this room may not be too familiar with what collective management is and its importance to thriving publishing ecosystems. So just to give you a very brief example of the role that collective management can play in fostering thriving publishing sectors. For example, in Australia in 2023, the Australian RRO Copyright Agency allocated 142 million Australian dollars to more than 36,000 rights holders. That's including publishers and individual authors. And this also indirectly benefits, of course, those many other people who would be involved in creative industries, such as in-house writers and illustrators. On a more individual level, collectively managed rights can play a very important part of revenue for authors. A study carried out in the UK a few years ago found that 25% of authors receive more than 60% of their annual income from secondary uses. This study also found that for authors, a 20% reduction in the secondary licensing income would result in the equivalent of almost 3,000 fewer created works being created annually. So effectively, RROs exist to offer efficient and comprehensive licensing solutions that facilitate fair and remunerated access to quality materials, and this benefits both users and creators alike. The creative industries, I think we all know here, the creative industries here undoubtedly have significant social impacts, such as promoting social cohesion, general well-being, and obviously contributing to improved education standards. But beyond these very important social impacts, the economic impacts of healthy creative ecosystems are substantial. As was noted in the 2021 report for the OECD Culture Working Group, cultural and creative sectors are a significant source of jobs and income, and also generate important spillovers to the wider economy. They are a driver of innovation, a source of creative skills that act as a magnet that can help drive growth in other sectors such as tourism and export. A 2022 UNESCO study also highlighted that the creative industries contribute significantly to national GDPs, with the publishing sector the single most important sector in most countries. The importance of IP protections and robust IP frameworks in fostering innovation and the development of sustainable IP-intensive creative industries must not be understated. Indeed, this was noted by the Director of the Hong Kong Intellectual Property Department, Mr. David Wong, in his keynote speech at IFRO's Asia Pacific Committee earlier this year. In observing that IP-intensive industries accounts for an extraordinary 32.7% of Hong Kong's GDP and 29.1% of total employment in Hong Kong, Mr. Wong emphasised the role of robust and agile IP frameworks in balancing the needs of users of IP products with those of the rights holders, that is, the IP owners and the IP investors, in order to foster innovation. So here comes AI. Where do we begin? Well, let's start with some truly extraordinary statistics. A recent PwC Global Intelligence report shows that AI could contribute up to $15.7 trillion to the global economy by 2030. That is more than the current output of China and India combined. Of this, 6.6 trillion is likely to come from increased productivity and 9.1 trillion is likely to come from consumption side effects. It's an interesting term, consumption side effects. We'll get into that later. The greatest economic gains from AI will be in China, with a 26% boost to GDP by 2030, and North America, a 14.5% boost, and that's the equivalent of a total of $10.7 trillion, and that accounts for almost 70% of the total growth, concentrated in 2 countries. According to OpenAI, ChatGPT acquired 1 million users in 5 days after launching in November 2022. By comparison, it took Instagram approximately 2.5 months to get to that 1 million mark. And Netflix, poor old Netflix, they had to wait 3.5 years to get to 1 million users. Statistics from the World Intellectual Property Office indicate that while digital technology patent applications have across the board grown 170% faster than average over the last 5 years, AI growth is sitting at over 700%. Generative AI now accounts for more than 1/5 of all AI-related patents, and this number is rising daily. If you believe the hype, and gosh, there's an awful lot of it out there, in terms of potential economic growth and consumer uptake, the opportunity of AI is enormous. It's hyperbolic. However, the rapid development of AI technology has also created a hugely unpredictable environment for creative industries and rights holders. On the one hand, and I'm sure many of you in this room as publishers, the creative sectors has shown great agility in deploying generative AI as a tool to assist creative works. And on the other hand, it's also very true that many are deeply concerned about the existential threat that generative AI can bring. Earlier this year, a very significant survey that came out of the UK of visual artists, and that survey revealed that 95% of artists feel that they should be asked before their work is used to train AI systems. 93% of the respondents felt that they should be credited where their work is used to train AI. 94% of respondents felt that they should be compensated financially when their work is used in training AI models, particularly those that are generating vast financial benefits for the tech holders. Crucially, 96% stated that they had never given permission for AI models to be trained using their works. So the concerns are not unfounded, and they can be understood from a number of perspectives. Firstly, there is the profound unfairness in the training processes. Soon after the advent of openly accessible AI tools such as Stable Diffusion, DALL-E, and Midjourney, creators, particularly visual artists, were very quick to call out the concerns about their works being used to train AI without their permission and without pay. In exposing the Books 3 database in a series of articles for The Atlantic, and if you haven't come across these articles, I really urge you to read them. Throughout 2023, the journalist Alex Reisner highlighted the rampant and unfettered use of unauthorised copyright materials in training generative AI models, all done without consent, acknowledgement, or remuneration to the creators. There's also a total lack of transparency, not just on the inputs, but also on the outputs. Generative AI tools are increasingly able to produce works or images or outputs that can look exactly like photographs, illustrations, and other artworks and texts that an average person may not be able to distinguish from works made by a human. Moreover, and this is the kicker for me, it's been demonstrated by many studies, and most notably very recently by the 2024 Stanford University AI Index report. It's been demonstrated that generative AI tools persistently produce exact replicas of copyright content, whether this be huge swathes of text from War and Peace, whole scenes from movies, or whole images such as the one I'm going to show you on the next slide. Now, whether such output actually constitutes as copyright violations is a central question before the courts right now. But the fact that generated content can contain copyright materials, I think, is absolutely indisputable. The third aspect here is the complete lack of reliability. As noted in the World Intellectual Property Office's AI Policy Toolkit, while today's AI tools may be very good at summarising text or finding answers to frequently asked questions, they still have very grave shortcomings. According to the WIPO toolkit, if a generative AI program is asked, for example, to produce the resume of a specific person, it is, and I quote, likely to generate a plausible looking piece of text. In fact, it is likely to read so convincingly well that the reader is lured into thinking that it is factual information. But the chances are that many of the entries, such as work placements or experience, are pure fiction. The program will simply have combined words in the most likely statistical order without any real understanding at all. Crucially, AI programs have no notion of truth. They have no understanding of social norms, and they have absolutely no regard for ethical behaviour. AI programs will need substantial post-processing of their output to adhere to such norms. And I was really delighted to hear from our speaker this morning, coming from the tech sector, affirming that view. So this next slide here. This image illustrates very well, I think, the point that was made in that 2024 Stanford University Index report, that generative AI tools often produce exact replicas of copyright content. And interestingly, this image was featured in the South Korean government's generative AI and copyright guide. And the employees of the South Korean government actually created this image themselves by inputting prompts such as Snoopy and Winnie the Pooh. And as you can see, the AI tool, I believe it was a Microsoft tool, it produced Snoopy and Winnie the Pooh. So creators and rights holders have filed very high-profile lawsuits against tech companies who own or control generative AI models, and I believe Theresa will be running us through quite a few of those cases later on. And these cases are claiming mass copyright infringement. While these court cases are being heard, governments are increasingly alert to the risks of AI being used, and I quote here from a Reuters article, AI being used to disrupt democratic processes, turbocharge fraud, and lead to dramatic job losses, amongst other harms. So governments are looking at regulation at international, regional, and also national levels to ensure the ethical development of AI that promotes the well-being and safety of their citizens. Efforts from international bodies include from the UN, which established an AI advisory body in recognition that the rapid advancement of AI not only brings new opportunities to reach sustainable development goals, but also brings substantial threats and challenges. Earlier this year, the UN's General Assembly unanimously adopted a resolution calling for the development of AI as a good for all, noting that AI systems should help promote and protect human rights and should be safe, secure, reliable, and trustworthy. WIPO has developed a new IP policy toolkit for regulators and IP officers in order to provide policymakers with a framework to understand the current state of play for AI innovation, but also to think of the future of AI as AI becomes more and more autonomous. And the OECD in June just published a new report outlining 6 key policy areas, policy considerations for AI data governance and privacy, emphasising the importance of transparency, accountability and security in AI systems. At a regional level, the EU, I'm sure everyone here has heard of the EU AI Act. It's been the absolute front runner in terms of legislative developments, and it was passed by members of the European Parliament in May, and I think news just came out yesterday or maybe this morning that it is now due to come into force in August. The EU AI Act is notable in its risk-based approach, and it sets out very clear requirements based on a risk-based assessment. So it restricts certain high-risk activities, such as biometric surveillance, but critically, it also obliges AI developers to provide transparency over what has been used to train AI models. The text of the AI Act has been largely welcomed by the rights holder and creative community, as it does go some way to addressing our concerns. And for those interested, there is a position statement at the link on the slide, which I believe will be shared. But the big question remains whether these rules are actually going to be implemented in a meaningful and effective way. It's essential that generative AI providers are required to adhere to very clear and very robust transparency standards in order for the effective exercise and enforcement of copyright. We can't enforce something if we don't know what's in it. The EU response has been both lauded and also criticised for being too prescriptive. On the other side of the spectrum, we have the very light touch ASEAN AI guidelines, which simply sets out 7 guiding principles aimed to help to ensure that trust in AI and the design, development and deployment of ethical AI systems. I won't go through all the principles, but they're the usual things: transparency, fairness, security and safety, privacy and data governance, and importantly, human centricity. At a national level, activity has been, oh my goodness, everyone has been so busy, but concrete responses are very thin on the ground at this point in time, and they vary widely. Many jurisdictions, including in the United Kingdom, in Canada, Australia, New Zealand, South Korea, Vietnam, really all over the globe, have carried out or are about to initiate extensive public consultations to assess the path forward for effective regulation of AI and generative AI. While some countries are considering following in the EU's footsteps, others, notably the UK, have taken a much softer approach to regulation, and they're urging players from across different sectors and industries to work together to reach a code of practice on AI. Across many jurisdictions, TDM exceptions are also under scrutiny. So in the EU, actually, there are fairly clear parameters around excluding commercial purposes, and there's also an opt-out mechanism. In the UK, I would flag that just last year, the UK legislators actually opted not to introduce a very broad copyright exception for TDM after an impact assessment on the implications of the changes on the creative industries was found that the UK Intellectual Property Office had taken insufficient account of the potential harm to the creative industries, and that whilst developing AI is very important, it should not be pursued at all costs. Other countries, notably Japan and Singapore, have taken steps recently to clarify their existing TDM exceptions in response to a potential proliferation of AI technologies, potentially relying on these exceptions as a defence for copyright infringement claims. And I understand the Hong Kong government has also recently announced a very similar public consultation on the TDM exception. There are a couple of key governance considerations I want to call out here as well. Firstly, back to that Stanford University AI Index report, it highlights that robust and standardized evaluations for generative AI are seriously lacking. The new research reveals a significant lack of standardization in responsible AI reporting. So all the lead developers, including OpenAI and Google, they all test their systems, their models, against different benchmarks. So this practice really complicates any kind of effort to systematically compare the risks and limitations of all the leading models. And this leads me to my next point, which is a very uncomfortable truth, which is that AI technology is currently in extremely concentrated hands of a few tech companies. And this raises quite serious concerns about abuse of market power, obviously, but also homogeneity and the perpetuation and embedding of biases, unconscious or otherwise. A recent MIT review article indicates that, and I'll quote it here, with vanishingly few exceptions, every startup, every new entrant, and even every AI research lab is dependent on these firms to an extent or another. All rely on the computing infrastructure of Microsoft, Amazon, and Google to train their systems, and on those same firms' vast consumer market reach to deploy and sell their AI products. So we're talking about, what was it? However many trillions of dollars in the hands of 3 tech companies and maybe 1 or 2 governments. So this brings me just down to IFRA's position. Effectively, IFRA's position is that responsibly and fairly trained AI tools that use authoritative, trusted content and respect copyright laws and copyright owners will produce better outcomes for everyone for several reasons. First and foremost, cultural and creative sectors are crucial to society and crucial to our economy. The European Parliament, for instance, in its 2020 resolution, emphasised the importance of human creators and highlighted that creating an environment conducive to creativity and innovation by encouraging the use of AI technologies by creators must not come at the expense of the interests of human creators. And at IFRA, we firmly believe this. Copies are undoubtedly being made in the training of LLMs and generative AI tools, undoubtedly. And copyright laws must be applied to those the copying of protected works. It's our view that licensing is really the most effective approach to bring AI technologies and copyright together. Lawsuits and litigation will take a long time. Lawsuits, litigation and legislation particularly, will take a very, very long time, and likely we're not going to get to any kind of harmonisation across different jurisdictions. Licensing can help now by enabling copyright owners and users agree on how to responsibly use copyrighted works. Both individual licenses and collective management solutions are already very widely available in a variety of markets, including the text and image-based markets. Collective licensing is also particularly beneficial when there is a need to use materials from numerous or a plethora of rights holders, as is obviously the case when using works to train AI systems. So collective licensing models can provide sound and efficient and fair ways to protect authors, rights holders, artists, publishers, and other creators, as well as protecting users by ensuring that the content that these AI systems are ingesting are of high quality, so what the AI systems are outputting will also be of a high quality. Ultimately, IFRA holds that AI models should only be trained on legally obtained data sources, which are transparently reported, and that rights holder opt-out or opt-ins must be fully supported, implemented, and respected across all jurisdictions. As highlighted earlier, RROs exist to offer efficient and comprehensive licensing solutions that facilitate fair and remunerated access to content. The landscape of text and image-based licensing is evolving very, very quickly, and the need for efficient and transparent collective management mechanisms has never been greater. RROs, with our existing international networks, are very well positioned to, and also, indeed, we really must adapt to the AI times. It's really easy when we're talking about AI to get caught up in the hyperbole and the tech jargon and to start talking about, all the different tech words I hear thrown around. So I really wanted to just close with this very salient quote from an author who puts it very succinctly in my view. I want AI to do my laundry and dishes so that I can do art and writing, not for AI to do my art and writing so that I have to do my laundry and dishes. So thank you very much for your time and your attention.
Thank you, Sarah, for the very insightful sharing. And we know more about the common core principle on AI governance and ethics. So now may I invite Andrew to share the situation in Singapore. Andrew, please.
Yeah, thank you, Sharon. Hello, everyone. My name is Andrew, and I represent an organization very similar to Hong Kong Reprographic Rights organization here. We're known as the Copyright Licensing and Administration Society of Singapore, or in short, you just call us CLASS, C-L-A-S-S. So interestingly, just before I want to start my presentation, earlier? Okay. I just want to come back to this one because interestingly, when Sarah shared that about this, I want AI to do my laundry and all this, and was it 2 days ago, I was just having dinner with my friends, and he's a big technological person. Everything to him has to do with technology. So he has this fish tank at home that he set up that I think daily they will extract a certain amount of water to water the plants, and then once the level of the fish tank goes down, then it'll pump some water back into the fish tank. So we think that technology is so useful, so he's been working for so long and so well and fine. And then as we were talking, there was a call, and his wife said that the fish tank overflowed with water because your sensor has spoiled. So as much as I think we want AI to do our stuff with us, we have to be mindful of their strength and their weaknesses. I think all of us here are intellectuals. We are in the publishing industry. We should know how to use AI to enhance what we do and what not to use for AI. All right. So moving on. Again, just a quick introduction. Again, just like you, I come from the publishing industry. I've been in publishing for the last 25 years. I've worked across a couple of publishing firms, mainly in educational publishing. So I am not legally trained. So sometimes when we talk about IP and all this legal stuff, it seems very difficult for me to understand. I think many of you should feel the same way as me if you're not legally trained, right? You look at all the laws, all the policies, and you talk to people, Article 43, 44, what are all those things? So for me, whatever I'm going to share today is things that I can understand. So hopefully, if I can understand as an industry professional, you should be able to understand it clearly as well. Secondly, what I want to share before I start with my presentation is that the few of us here come from an industry that is a bit on the other side of the fence to the people you have heard this morning. So I think for the people who are here this morning, they are inventors, they are creators, and they share a lot of the good of what AI can do. And I think none of us here is disputing the fact that AI will do wonders for us. I think what we're trying to say is we should look at AI in two different sides, what it can do good and what we have to do to ensure that AI continue to build our business and our lives for us. So I'm going to share quite quickly 4 key things that has happened in Singapore. These are my personal views, and this is what I want to share as clearly as I can as a Singapore's government view. It is not in any sense of us endorsing any of these points that we've put up. And I also understand that the Hong Kong government has put up a consultation paper on the text and data mining exception. So whatever I share today is really just what we have adopted in Singapore. It's not supposed to mean anything else. It's not to shape any of your policies for you. It's not a blueprint. So the first thing is that we have a Copyright Act in Singapore way back in the 80s, and it served us very well. And we typically update the policy every 4 or 5 years. And the latest update we did was in 2021. And this was for computational data analysis or text and data mining thing. So this new exception, what it does is that it allows the copying of copyrighted works specifically for the purpose of computational data analysis. So I think the word computational data analysis is important because at a point in time where we did this policy, and that was in 2021, it was still before all the big boom about artificial intelligence, right? And if we know that if a government is going to have some policy in 2021, they would have started their thinking 3 years, 4 years ago. And during that time, AI was still very, very early. So when we had this exception, I think a lot of thought wasn't given into the impact of what a policy might do to AI developers as well as copyright owners. So what this means is that it allows companies a lot of defense mechanism. That means I can make use of materials from copyrighted work so long as I follow certain boundaries, which I'll share later, and you cannot find fault in me because the laws allow me to do that. Okay? So what does it mean? So computational data analysis, or CDA exception, it simply means that you can use a computer program to identify, extract, and analyze information or data from the work or recording. So very much what artificial intelligence does. You extract materials to do its work. It used the work or recording as an example of a type of information or data to improve the functioning of a computer program in relation to that type of information or data. So it allows programmers or researchers to crawl data to make use of this data for their purposes, whether is it for research, for education use, or for commercial users. So what are the implications of this? The implication and the things that you need to take note of is, number one, whoever intends to use this must, number one, use lawful access to get the work. That means you cannot just use the work illegally, right? You cannot just use the work without asking for permission. You cannot use pirated copies of the work. But there is a big ambiguity here when you say lawful access. So lawful access doesn't mean if I just buy a copy of a book for $10, I can use it to train my data. That is also lawful access, right? I just pay you $10 instead of paying you, I don't know, $10,000 for your rights. So again, this is very, it's quite hazy. It's not clear enough. Secondly, there are no contract overrides. That means you are not able to use a contract to override the government's decision, the government policy. So you cannot use a contract to say that, okay, because of this contract, I state this term. You can't. So no contract overrides. The other thing I forgot to put inside here is that it covers both educational as well as commercial users. That means this text and data mining actually allows you to use it for commercial work as well. The exception applies only to acts performed in Singapore. So if you want to do all this legally, you can do it in Singapore. So long as the work is being created in Singapore, you're covered. So this is quite a very large and over-encompassing exception because it allows you to do a lot of things. And there are quite a number of loopholes. So obviously when this TDM exception goes out and when the public saw it, there were a lot of feedback, both locally as well as internationally. So what happens is sometime in December last year, our ministry decided to come up with a response to some of this feedback. The paper is over there at the bottom here. There are some blue color words that that's where you can download the whole paper. I'm not going to show you the whole paper here because it's very long. Hopefully you can get a copy of this presentation. You can have a look at the paper. But essentially what it does is it tries to explain the Singapore's position, why the TDM exception was invented this way. But very interestingly, the people who responded to this are the head of the legal team from the Intellectual Property Office of Singapore. So they are the head of the legal team there. But when they drafted this paper, they drafted it in their own capacity and not answering on behalf of the Intellectual Property Office of Singapore. So in some ways, it is not a response by the government. It is it's a personal response from the head of legal. So whichever way you look at it, how you interpret it, why is the government not responding, why are they getting their legal head to respond in a personal capacity is up to us to guess, right? The other thing that the government has put out recently, so in Singapore, there are a couple of agencies that deals very much with copyrighted material. So on one hand, you've got your Ministry of Law, your Intellectual Property Office. Then you've got the Ministry of Education, who has been keeping quiet for a very long time. I think they're just taking cues from the MinLaw. We also have another agency called the IMDA, which is the Infocom Media and Development Agency. So IMDA typically works with technology companies. So they want to work with new technologies. They try to attract technology companies to set up in Singapore, provide them with the basis to grow their company in Singapore. So they came out with a paper, I think first quarter of this year. What it says is they want to create a trusted AI ecosystem. So within the paper, it touches in detail a lot of things about AI, how you need to be accountable, how it makes it easier for creators to use AI materials in Singapore, how it creates an ecosystem, the security, and all these sort of things. So I've been reading it from page 1 to the last page. I've been crawling through the entire document. So the whole document talks about creating a very good ecosystem in Singapore. So developers will be very happy because they can come and create things in Singapore very cheaply, very easily. But what I was trying to locate was the point about protecting the rights of the copyright owners. So I don't seem to find it anywhere in the document. So that means, on one hand, I think the government looks at creativity in quite a narrow sense. They only look at how to make it easy for things to be developed, but they fail, or perhaps it's not intentionally, but perhaps it's unintentionally, fail to see the other side where, where do these things come from? Right? It has to come from somewhere. It comes from you, your publishers, your content owners, but it's not mentioned in the document. So I only found one very small explanation, which is on page 8, under the footnote section, where it talks a little bit about fair remuneration for copyright owners. So it tells a lot about what our government is thinking about the creative sector and how well copyright owners should be paid. It's only worth a mention in a footnote, not even in the main document. Okay. There are also other things that was published also early this year. So this publication is by the Intellectual Property Office together with one of the universities in Singapore, Singapore Management University. Again, it talks a lot about the landscape of artificial intelligence, making a lot of references overseas, locally. They made references to the US, to the UK. It talks a lot about what things can be done there versus what things can be done here. Again, I read through everything. Very little or none talks about protecting rights owners' interests. So why is it this way? So we keep asking ourselves, why is it this way? So I think, again, this is my personal opinion. It is not, I did not consult this with the government at all. I think I think one of the reasons could be because of a vision that the Singapore government has put in place. We have a Singapore IP strategy for 2030. So what the Singapore government hopes to do is by 2030, we can grow Singapore into a huge content hub. We can attract people to come to Singapore, to create their companies here, to create content here, and have content built out of Singapore. So I think maybe because of that, and we have Singapore pumping $17 million in to develop the first LLM with Southeast Asian context. So maybe because of that, because of the journey, the 10-year journey of where we want to get, maybe it could be because of that. That's why we are lowering the barriers for people to come and makes lives easier for content to be developed. Whether that is the right thing to do or not is debatable. As a publisher myself, working in the copyright industry, I think, coming back to my first point, we are not denying the fact that AI will be useful, but I think we need to come together in a concerted voice to tell everyone that, yes, you can use our content, but if you make money, please make sure that you share some of the profits with us as well. Right? So this is the last thing I want to leave before I end my presentation, is that I think the best things in life are not for free. So if you want good things, pay for it. Thank you.
Thank you, Andrew, for sharing the situation in Singapore. And actually, when I first recently received a consultation paper from the Hong Kong government on some changes in legislation with regard to AI, and I also started communicating with, Sarah and Andrew on, regarding this topic before we prepare a paper to the government. And after Andrew, we will hear from Theresa. Theresa, she's from the Dickens, the very reputable IP lawyer. They have the very reputable IP lawyers, team in Hong Kong. And Theresa today, she will share some IP infringement concern, and it's very lucky of us that she will offer some free tips on minimizing IP risk. So, Theresa, please.
Thank you, Sharon. So I'm here today to talk about the various IP considerations, which we all know can arise when in the use of generative artificial intelligence, as we know that the use of generative AI can be fraught with quite a number of issues, not only for AI, but ethics, transparency, data privacy. So we'll focus on IP today, as it's a very big topic. Right. So today, the topics that we're going to explore, first, I'm going to cover some of the main IP infringement concerns for use of generative AI, and then we'll go to the ownership and subsistence concern that a lot of people are usually worried about, and then end off with some tips to minimize IP infringement when using this type of technology. Sorry, I must be pointing the wrong way. Okay, so when we use generative AI, very broadly, you can run into these type of IP infringement issues here. There's passing off, trademarks infringement, copyright infringement. In terms of that, it can come in both two ways. There is the infringement by the output that is generated by the AI platform, as well as within the training data sets that we have mentioned by the earlier speakers just now. And I will go through each of them in turn. So in terms of passing off, we all know that there are platforms out there that can generate deep fake pictures of celebrities and public figures that look very real. For example, this example out here is using the Midjourney platform. Somebody put in the text prompt, Brad Pitt in a jungle. And it was able to show very clear and stunning images that makes you think that it's actually a real still shot from a movie or an advertisement. So if you use these type of images that contain the images of famous people or celebrities, which owns goodwill and reputation in terms of their images or even their voice, then if you use it in commerce, then there could be passing off issues. So for example, if today you're shooting a commercial and then you decided that, okay, these pictures look quite good, why don't I use them in my commercial without his consent? Then in that case, the public may be misled into thinking that he is endorsing your commercial or you've obtained his consent in order to use his likeness in the commercial, and that could amount to passing off. For trademark infringement, I'm sure a lot of us here have looked at this case previously already. We know that Getty Images is suing Stability AI for copyright infringement and trademark infringement in the US as well as in the UK. So the complaint is that Stability AI has used over 12 million copyrighted images, descriptions, and metadata to train the Stable Diffusion training data set. And in doing so, because they basically just crawled the Getty Images online, which contains the watermark, you can see that the output on the right, so that the image on the left there is Getty Images' original image that you can find from the website. And the image on the right there is generated by the Stable Diffusion output. And you can see that not only the photographs look somewhat similar in terms of the positioning of the people featured, but also the Getty image trademark, a crooked version of it, can be seen on the picture as well, showing that basically they have a lot of these Getty images with a watermark in their training data set. So the cases are still currently ongoing in the UK as well as in the US. So we're yet to see what the court will say about copyright and trademark infringement. But basically, Getty Images is demanding US $150,000 for each image as damages, and also seeking a total of US $1.8 trillion as compensation. So in terms of copyright infringement, I mentioned just now there is the output infringement as well as the training data set infringement. So for output infringement, case example, I'd like to talk about this relatively recent PRC case that features Ultraman. So basically, the claimant is the PRC owner of the design rights and copyright to Ultraman, and the defendant is a platform that hosts an AI drawing function. So the claimant went onto the defendant's platform and put in text prompt such as generate Ultraman, and then the 4 squared images that you see here are the images that are generated via the AI platform. This full-size Ultraman here is actually the claimant's copyright work. So you can see that the 4 Ultraman images generated are, they do look like substantial copies of the claimant's original copyright work. So it was held that by the Guangzhou Internet Court that the output does infringe the claimant's copyright. And in deciding that there is infringement, the court actually looked at whether the defendant had the ability to block certain keywords from its platform. And it's found that the defendant actually had the ability to do so. So for example, the platform could block the word Ultraman. So then if the user puts in the word Ultraman or Winnie the Pooh or Snoopy, then they can actually block the platform from generating something that literally resembles those characters. So in addition to that, the platform has also failed to adopt various preventative steps that are actually required under PRC law, such as they have no user agreements or platform policies prohibiting the users from generating infringing content. There's no takedown mechanism for any infringing content. No warning to users that the AI-generated images could be infringing, and also no indication to the platform users that the platform actually uses AI to generate its images. So in the end, the defendant was ordered to pay renminbi $10,000 in damages. In terms of the other type of copyright infringement infringing data sets, there are actually a lot of copyright lawsuits currently being pursued in the United States. So this one that I'm going to talk about relates to publications in particular. So in the US, a group of authors have filed lawsuit against OpenAI for using their copyrighted work to train the ChatGPT data set. And the reason that they know is because when they put in the appropriate prompts, ChatGPT was able to formulate accurate summaries of their books. So that's how they deduce that the book itself must have been fed into the training data set. So they have taken OpenAI to the court in the United States and claiming for copyright infringement and unfair competition. And OpenAI has tried to dismiss the unfair competition claim, but in dismissing this application to dismiss the copyright infringement claim, the court held that if OpenAI is in fact using the author's copyrighted materials to train their language models for a commercial profit, then this may constitute unfair practice, and therefore OpenAI was not allowed to dismiss this claim. So far, there has not been a decision yet as to whether the use of materials to train the AI dataset would be copyright infringement, but it is expected that in the US, OpenAI would argue fair use under US copyright law, that the use itself is transformative and therefore non-infringing. So the US fair use provision is quite different from the one in Hong Kong because that one is it's very US specific, and the way that they apply is quite different. So as far as Hong Kong is concerned, the current fair uses defense we have here is actually quite specific. You first have to look at whether whatever that you do falls within that type of activity that has the defense, and then you look at whether or not it's fair. So currently, as the law stands in Hong Kong right now, if you're using copyrighted work to train AI data sets, and in using so you have storage or copying of these works into your data set, then that would amount to infringement. So the next item to explore is the IP ownership and data subsistence. Generally, right now, the governments, they have separated this into two different camps. So one camp is, for example, the US position, where the US Copyright Office has rejected copyright protection over AI-generated work because it is not created by human. So this example up here is an image that the creator first created by using Midjourney. In creating this image, the person actually inputted 624 very detailed prompts to generate the initial image that the person wanted to generate. Afterwards, the person used Adobe Photoshop to remove some flaws and then used Gigapixel AI to upscale the image. And because under US law, they find that copyright protection is very human-centric in the sense that only human-created works can enjoy copyright protection. So in this case, the US Copyright Office actually rejected the copyright registration application as they view that the initial image was created by AI and therefore not by human and cannot enjoy copyright. Whereas, on the other hand, there are a lot of jurisdictions, such as PRC, that falls under another camp, which decides that there could be instances where AI-generated work can be protected by copyright. So I want to illustrate it with this PRC case, where the claimant had used Stable Diffusion to generate a photograph that we see on the slide there. And in generating it, the claimant also used very detailed positive and negative prompts. So what this means, positive prompts, for example, can be, I want a picture to look like, to show a human, a Japanese idol who looks shy, elegant, in a cool pose, etc. And the negative prompts would indicate what the author doesn't want the picture to look like. So for example, in this case, there were prompts such as it should not be a painting, it should not be a cartoon, etc. So the claimant has posted this image on social media with hashtags telling people that it is an AI illustration, an AI drawing. The defendant copied this image, posted on another social media without authorization, and the claimant took the defendant to court. So for the court, in considering that there is copyright infringement, before doing that, the first thing to do is to assess whether or not copyright actually subsists and is owned by the claimant in the first place. So in terms of subsistence, the court held that there was original intellectual input by the AI user, and that's because the user has spent time and effort in conceptualizing and designing the picture with very detailed prompts. So the prompts itself actually reflects the aesthetic choice and original judgment in the image structure. And then in terms of the ownership, it was the decision between either the AI model, AI programmer, or the claimant as the AI user. So the AI model itself, because it's just a model, it's not a legal entity, so then the model itself cannot own the generated work. But in terms of the programmer, even though the AI programmer created the AI model itself, but what we're trying to say as copyright work in this case is the intellectual creation that actually went in order to generate this picture. And the court held that the programmer was not involved in the particular intellectual process and the prompts in order to generate this image. And in addition to that, the terms and conditions of Stable Diffusion actually expressly states that Stable Diffusion is not to own any of the right in the output content. So in this case, the court held that the AI user, which is the claimant, would be the copyright owner of the picture. So this is one example where AI user can be the copyright owner, but I'm not saying that this is an inevitable case that AI users are always copyright owners, because ultimately it always have to depend on a case-by-case basis, what prompts are used, whether the prompts are detailed enough in order to generate the picture, and then we'll see from there whether it is the AI programmer or the AI user who owns the copyright. So what is the position in Hong Kong? So the position in Hong Kong is likely to, well, it falls under more of the second camp, where the law actually does recognize there could be copyright protection under computer-generated works. So the law itself allows authorship and ownership for computer-generated works, and by definition, what a computer-generated work is a work that has no human author. So in that case, Hong Kong law recognizes that the author is to be taken as the person who's undertaken the arrangement necessary in order to create that work. So on a plain and literal reading of a Hong Kong law, we see that Hong Kong law does recognize copyright subsistence in AI-generated works, but that's not the end of the matter, because there are still quite a number of unanswered questions, such as, okay, we know that it subsists, but who is to, well, we know that the person who makes the necessary arrangement is to own it, but who is this person? Should that be the AI programmer or the AI user? Or is use of the copyright materials in training data set infringing? Or should there be any defenses to that? And also, if there is found to be IP infringement in using generative AI, then who should be liable? Whether it should be the AI programmer, the AI platform, or the user. So these are all unanswered questions right now. And in the face of these questions, as we've mentioned earlier by various different speakers, Hong Kong has plans to amend its copyright law in order to address certain issues that arise from AI usage and development, with a view to further promote AI industries in Hong Kong. So just last week, fresh off the oven, the Hong Kong government launched a public consultation paper on enhancing the city's copyright law in order to provide for AI technology while balancing the rights of copyright users. So the government is now seeking views on issues such as the copyright protection of AI-generated works, the copyright infringement liability for AI-generated works, and most notably, the possible introduction of a text and data mining TDM exception that we mentioned earlier under Hong Kong copyright law. So this exception seeks to allow use of the copyright work for computational analysis in order to generate patterns and trends, as well as train computer programs such as AI models. So we know that there are different versions of these TDM exceptions that are currently existing in various different jurisdictions. So the government is inviting views on different points, such as the justifications for introducing this TDM exception in Hong Kong, and if this exception is to be introduced, what the limitations should be. So before we have this copyright amendment that takes into account of the effects of AI. Use of generative AI is still fraught with a lot of infringement issues at the moment. So I'll share with each of us some tips of how we can best try to minimize it. Firstly is to make sure that you do check the data origin of the AI platform and use trusted AI platforms. So for example, we see just now that there are some platforms like Stable Diffusions out there that actually, are embroiled in lawsuit right now. So the next time if some people in your organization saying that they want to generate images using Stability Diffusion, then, think twice and make sure like you do the appropriate checking. Secondly, also check the warranties and indemnities because in some of the versions of the AI platforms, particularly the paid ones, sometimes they would provide you with certain level of indemnity for infringing output content. And in terms of the ownership, it could also be different depending on whether you're using a free version or a paid version. A lot of the times, if you're using a free version, you might see that the output is actually owned by the platform itself. But whereas if you're using a paid version, a lot of the times they will allow the AI users to own the output. It's very important to develop guidelines on the AI use and also document on the process. The point of developing your organization's guidelines on AI use is to educate your employees on the responsible use of AI, how to use it in a way that minimizes infringement. And in terms of process documentation, as we see from the PRC case involving the girl in the picture just now, when you want to prove your subsistence and ownership of any copyright in the output, a lot of the times you do have to take out the creation process and explain to the court how everything was created and the prompts that are used. You may also conduct due diligence to verify the legality. So for example, if you've generated an image, then you can try to use reverse image generators in order to see whether the image is actually taken from elsewhere on the internet. If possible, try to use private AI solutions. The good thing about using a private AI solution is that you can control what goes into the data set. So firstly, you will have control over the quality of the data to try to prevent or minimize hallucinations. And second of all, because these data sometimes could be infringing in the open platform. So then you can also make sure that you have obtained the appropriate licenses to include those copyright information to train your data set. But most notably, actually, the benefit of using a private AI solution is confidentiality. Because for corporates, we a lot of times we have confidential information, especially, for example, law firms. And if you feed this information as prompts into the AI platform a lot of the times, most of the time, will actually use these prompts as well as whatever that's generated to feed it back into its own platform to train the data set. So if you include anything that's confidential into the prompt, then you're already leaking your confidential information out to the public. So lastly, very importantly, stay informed of the technology and the law. Technology is developing very rapidly, and the law is also constantly being amended and consulted in order to cater for that. So if there's anything that you're not sure whether or not you can do, then always seek legal advice. All right, so that forms part of my sharing today. Thank you.
Thank you, Theresa, for your sharing. We just heard from Sarah, Andrew, and Theresa on more on the policy and legislation perspective. Now we turn to another perspective on technological impact with regards to the AI and copyright licensing. So may I invite Sam for sharing? Sam?
Thank you, Sharon. And I'd like to thank Sharon from the Hong Kong Reprographic Rights Licensing Society for inviting me along with the Hong Kong Trade Development Council. It's a great pleasure to be here. I was only in Hong Kong 2 months ago, so it's becoming a second home. It's great to be back. What I want to talk to you today a bit about is around sort of the technology impacts, but also how collective licensing can work with AI and in particular generative AI. And I'll talk a little bit about, Theresa talked before just now about a closed system or private systems, and open systems and the differences in those, I think is quite important for everyone to be aware of as well, because it does have or can have a massive impact, more so in the corporate world rather than in the creative world where we tend to operate a lot more. So just a little bit about us to give you some context around collective licensing and what we do as a CMO, a collective management organisation. So we're owned by, like they are in Hong Kong, by the Writers, Authors and Publishers Associations. We have just moved into visual art, and we now are managing the resale rights scheme for the New Zealand government, and launching in December this year, where visual artists in the secondary market get 5% of the sale price returned to them, which has been the case in a number of jurisdictions in Europe, the UK and Australia for a long time. So that's been an interesting development for us, and part of a free trade agreement that we signed with the European Union and the UK. So our purpose is to make creative rights work for all New Zealanders, and I think that's really important when looking at licensing and collective licensing. It's not only about the rights holders, but also about licensees. So how do you make it easy for a licensee, like a business working with AI systems, to use data to ensure that they're getting appropriate outputs? So it works both sides, for rights holders and also for licensees. And our strategic goal is to empower and promote our creative people and enable creators to get full value for their rights, because that's what makes the economic world go around for creators. They need to get a fair compensation for their work. Otherwise, we won't have writers, authors and publishers if we rely solely on generative output from AI. So this is the circle for a CMO. It starts by selling a license. You then get license income and you distribute that back to rights holders. The license itself must have value. So if we're looking, and I will look later at how that value could manifest itself for an AI system, because the license isn't just about having the ability to use that content. It's about the fact that it's giving you safety of the input, and therefore as an output you get the same as well, so perhaps less hallucinations. We also, as part of our constitution, take 2% of all our revenue and give that back out to the sector as grants or awards, and so that generates a more vibrant sector as well. We also use our expertise to help both rights holders and license holders, and that's a benefit of collective licensing rather than just direct licensing. So where a publisher goes direct, say for example to an AI business with a collective license, you're able to provide experience across all rights holders and licensees. And advocacy, so as we're all going through in the world at the moment, everyone's generating or looking to generate policy around the safe and fair use of AI. So we are at the moment spending a significant amount of time thinking and doing work with advocacy with our government. So just a bit of a position around where we are around generative AI. So I think, as all the speakers have said, who are CMOs, is creators and publishers have actually been the most affected, or could be the most affected by the speed and scope of development of generative AI, and that's both positive and negative. So I think the key statement here is that copyright, you can be both pro-copyright and pro-AI, and the Copyright Clearance Centre just came out with a license yesterday for internal use for corporate licenses of AI, or of content into AI. So once again, using that within a closed network. So there's a really good example of being pro-AI and pro-copyright. And there's a list of points down there, and I think the ones that are probably of sort of you might have some difficulty with is the significance and impact on Māori intellectual property. We have Indigenous rights within New Zealand, the Māori people. We have a treaty that we are bound, or it binds some of our law around intellectual property rights and also property rights in general. And there's quite a discussion going on in New Zealand around that as to the extent of those rights and how much of that is co-governance or separate governance. Text and data mining exceptions must allow for an opt-out, and I think that's really important. If and as we've seen in Japan and Singapore, there is this grey area around opt-out, or in fact there is no opt-out. You must really allow creators to say, no, I don't want my work to be included within that, or that if I'm not getting remuneration for it, then I'm allowed to opt out. So, as with any commercial decision, it should be able to be included, so that I do or don't want to be in there. I think down the bottom are some really interesting things around policy changes should not harm existing markets, and we are perhaps seeing some of that at the moment, and I think that's important as you go through that process here in Hong Kong to, you're a very vibrant cultural centre, so whatever you're doing to promote the use of AI shouldn't harm existing markets, it should add to them. Education is essential. A lot of times people who use AI aren't aware that they may be infringing copyright with the outputs they're using, and we've had examples in New Zealand recently of marketing organisations using images that use copyrighted data without permission and have had to stop using that campaign. So I think that's something that we need to do a better job of, perhaps, is educating people around the right and proper use of copyrighted material. And just the last one for us, which is a new agency maybe. This is new. I mean, it goes across all sectors, not just the creative sector. We see significant positive impacts of AI in New Zealand in things like agriculture and industry. So, there's certainly a lot to be gained from it. I just thought I'd put this in here, which is Adobe, who obviously are used probably by most people in this room, and they have a very, if you like, pro-copyright, pro-AI position. And if I just read out what Ellie Greenfield, who's their CTO, said, Adobe wants to reap the benefits of generative AI while still recognising they are built on the back of human labour, and we have to figure out how to fairly compensate people for that labour now and in the future. And I think that's a really important point to make. So they use licensed content for Firefly and others of their products. And I think that's a very good example of a corporate doing the right thing and acknowledging that without creators and the remuneration of creators, they wouldn't have a product to sell. The other thing there around the point they make is that it prevents misinformation. So having full transparency around what's being used and licensed within the Adobe products allows you as a user of Adobe products to know exactly what where that output's come from, and lessens business risk. And I think that's really important, particularly within the use of both copywriting and also imagery, that you don't bring risk into your business by using images created with AI that you don't have permission to use. So the key questions, the use of copyright material as inputs for AI systems, potential copyrights of the outputs from those, and then the copyright status of those outputs. And I won't go too much into the status of AI outputs, as it's different by jurisdiction. It's different in New Zealand as it is in China, as it is in the United States or Australia or Japan. So that's another sort of whole area. But I will just talk about some of the benefits of a collective licensing solution for inputs. And I guess the thing about collective licensing for AI inputs is it creates a more efficient, transparent and fair ecosystem for AI development. And it does that by giving you centralised access to training data. So large language models could be using data that's cleared for copyright, and therefore the outputs you get will be legal to use. Ensures data quality and standards, obviously. This was touched on briefly before about improving data diversity and transparency. One of the issues we have in New Zealand with AI, and this is more to do within health and education, is if you use some of those large language models, they do not include a lot of data for Maori or Polynesian peoples who make up 25% of our population. And the same is true within Asia Pacific, the wider region. Quite a lot of the data is quite centralised around Europe and North America. Obviously, revenue sharing, which is something that we've touched on, and then compliance and reducing administration of those rights. So, at the moment, OpenAI are doing deals with large media organisations, direct deals. However, you can't really do that with individual authors when you're using their books. So, obviously, they want to do licensing deals, but you can't do that with every individual author. So, collective licensing would be a very good solution for that for someone like OpenAI. Very similar for outputs. So it would allow for a centralised management of outputs. You would, as a user of AI, you would know that the output that you're getting has been approved and is standardised. Again, there's revenue distribution back to rights holders, and it would include monitoring and enforcement of that data as well. And I think one of the other things is about collective licensing. The reason we're here is we're part of a group called IFRO that provides for cross-border licensing opportunities globally. So Sarah talked before about the large number of countries and works that are represented by the members of IFRO. So there's already a solution in place for providing licensing opportunities globally for the data that's used in a lot of these large language models. Just lastly, this is something that we have developed in New Zealand recently. It's not in direct response to AI, but one of the benefits of it is that it enables creators to store their agreements, contracts, and their work in a centralised place. It will help with provenance. So when you're looking to provide licensing opportunities to AI, a service like this could work well for local creators to ensure that they have the mechanisms available to them to be able to license their work. So we're quite excited by it, and it's growing quite well at the moment. The other good thing about it is it does help educate creators around their rights, and that's one of the things we've noticed, particularly in our jurisdiction, that creators' rights is not something that's taught when I'm a writer, an author, or a visual artist, but it's something that needs to be known, and now perhaps more than ever as we see these a lot of infringement happening around some of these large language models. Thank you.
Thank you, Sam. So after Sam, we're going to hear the sharing from Takeshi on the recent Japanese, the change in the jurisdiction in Japan, and also Takeshi's from the news and journalism area. So may I invite Takeshi, please?
Yeah. Thank you very much, Sarah. Hello, everybody. My name is Takeshi Ikkanda from Japan. First of all, I really appreciate for inviting me here today and for the opportunity to make a presentation. Thank you very much. And I know you are all a little bit tired now, but this presentation is very last, so please stay with me a little bit longer. Thank you. Okay, so my presentation title is How to Deal with Generative AI from a Copyright Perspective. Now, at first, I'd like to introduce a report by the Agency for Cultural Affairs in Japan, compiled on March of this year. In this report, there is a description of the various concerns voiced by stakeholders, which is interesting and they are very well organized. The first concern is that copyrighted works are being used for AI development and learning without permission. And you can see the, how to point? Okay. The third point is that there is also concern that creators' job will be taken away by AI. So generative AI is spreading not only to text, but also to our illustration, music, and all other fields, and various movements are taking place around the world. So recently, the Actor Guild strike in United States is very fresh in our mind. The next slide is the concern of AI developers, AI service providers, and others. In a word, this concern is that it is unclear whether they will be liable for copyright infringement. As for the concerns of the AI users, this is the third one. From their perspective as creators of AI products, they have the same concerns as operators that they may unintentionally infringe copyright by generating and using AI products. And they also have the same concerns as operators that AI-generated material may not be copyrighted and therefore not subject to legal protection are held. And the slide shows the text of Article 30-4 of the Copyright Act in Japan. Just to say a few words, the report explains that AI can be divided into the development and the learning stage, and the generation and the use stage. And that even in the development and the learning stage, Article 30-4 does not apply if it qualifies as non-enjoyment purposes, or if it unreasonably harms the interest of the rights holders, and that there are cases where copyright infringement may occur. The report itself, the point of concern is that the report itself is not legally binding and does not provide a definitive legal assessment of the specific generative AI and the technologies related to it that exist at the moment. So it is difficult to evaluate how far it will have the effect of increasing the foreseeability of those involved until more time has passed. It may be that. Okay. And other governments and agencies in Japan have also expressed certain ideas on AI. For example, the Japanese government's tentative discussion paper on AI, published in May the last year by the AI Strategy Council, presents 7 risks of generative AI. Among them, the risk of copyright infringement is number 6, is presented as an independent item, along with the risk of the leakage of the confidential information and inappropriate use of personal information. But however, the risk of copyright infringement is not a standalone issue, but rather a complex interplay of other risks. For example, the risk of the losing jobs to AI, in 7th point, is the same as that indicated by the concerns of the creators and other right holders. And when it comes to content produced by the news organizations, apart from copyright infringement, it is also related to the risk of the false information in the 3rd point, right? Such as the issue of the fake news. Okay. The next slide. Thus, the issue surrounding AI and copyright are diverse and moreover interrelated, presenting a complex situation. In particular, the existence of the Article 30-4 has led some to argue that Japan is machine learning paradise, and that the Copyright Act should be reviewed. Here we can see the General Newspaper Association, specifically, they has issued a statement, Basic Approach to Generative AI, which call the creation of the system that at least allows copyright holders to refuse learning by AI, or at least requires the permission of the copyright holder. An important aspect of this statement is that it directly demands a revision of the Copyright Act and argues that it should be put in place as a legal system. As such, there are several organizations in Japan advocating for the revision of the Copyright Act, with 8 organizations from the field of music, art, and script writing calling for revision. Like this, some Japanese right holders associations have argued for a revision of the Copyright Act. But now, let us consider what kind of legal and institutional approach is possible in terms of legislative theory. Here, I would like to introduce the organization of Mr. Atsushi Okada. He is a lawyer of the Japanese law firm Morihamada Matsumoto. He presents 3 legal and institutional approaches as shown on the slide. So let's move to the first approach. Looking at the approach requiring the permission of the copyright holder, this approach states that the prior permission of the copyright holder is required for the use of copyrighted works in the AI development and the learning phase. This approach can certainly be a powerful weapon for right holders, but it is not so simple. The lawyer Okada pointed out the following challenges, the main issues. The first is that only a few companies with strong bargaining power can obtain licenses, which can lead to the bias in AI models. In addition, existing AI providers with vast amounts of learning data may gain an advantage, leading to an exclusive monopoly by certain AI providers. And as a practical matter, it is very difficult for rights holders to monitor the AI learning process. The following refers is to the approach that not require permission, but recognize the right to claim compensation. Japanese copyright law has precedents for this, such as the compensation system for public transmission for teaching purposes and for libraries, etc. So, Japanese stakeholders may find it familiar at first glance. However, this approach also has its limitations. In the first place, the public transmission compensation system for teaching purposes and for libraries are limited in terms of purposes, such as educational and research purposes. And there are also restrictions on the subject of the act of use. In contrast, it would be difficult to impose such restrictions in the case of generative AI. In addition, as noted on the slide, this one, the right holders will not be able to refuse machine learning. And the development and the learning process generated AI involves the reproduction of the vast amounts of content. It is making it difficult to create a mechanism to distribute compensation fairly to right holders. However, as a result of the strike by the Screen Actors Guild in the United States, as I mentioned, an agreement was reached between the parties concerned, including the obligation to obtain the consent of the actors targeted for the creation of the composite actors. Therefore, it might be impossible for the parties concerned to overcome these challenges by means of contract. And sorry, okay. And sorry, this is a slide. I'm sorry. I'm sorry. Wait a minute. Sorry. Yes, approach it. Process. I'm sorry. Approach. Yes, I'm sorry. I'm at a loss. Okay, the first one. Approach the second one. Yes, it is the, sorry, this is the last one. The last approach is that the approach of allowing copyright holders to opt out while not requiring permission in principle. A typical example of this approach is the TDM exception provision in EU directive. The Article 4 here, the rights holders may opt out of commercial use in appropriate manner. This is a very typical example. But this approach, even also, it is not easy to create an opt-out mechanism that satisfies both rights holders and the AI operators. And it is technically difficult for rights holders to effectively check whether they have really opted out or to extract and delete only some content. Thus, although there are certain voices in Japan calling for governments to amend the law, it is likely to be very difficult to solve the problem through legislative arguments. I mentioned before that several Japanese rights holders organizations are calling for legal reform, but in reality, their voices are not loud. Rather, it can be said that many organizations are exploring the possibility of using generative AI, while at the same time recognizing the difficulty of resolving the issue through legislative arguments. So, what is the global situation regarding generative AI? Here, I introduce very briefly the situation in the EU and the United States. The firstly, in the EU, as Sarah has presented already, the EU AI Regulation Act was passed on 21st May this year. This law, which can be described as the first international comprehensive AI regulation, is characterized by aiming to strike a balance between promoting the use of AI and protecting individual rights, with an emphasis on ensuring transparency and building trust with consumers. The evaluation of this regulation is divided, but the negative opinion is that this regulation will put the generative AI business in Europe far behind that of the US and other countries. The next slide is the United States. In the US, Executive Order on the Safe, Secure, and Trustworthy Development and Use of AI was issued in October last year. This order appears to be primarily aimed at protecting the public from the risks posed by generative AI, as it mentions the promotion of technologies to identify content created by generative AI, as well as security and privacy protection and support for workers. However, the pledge of Mr. Donald Trump was to repeal this order. So if he would be elected, he might be oriented towards the US leading the world in the generative AI industries. As regards Japan, the guidelines prepared by the Ministry of International Affairs and the Ministry of Economy and Trade and Industry, which I introduced earlier, state that it is important for all the business involved in AI utilization to voluntarily promote specific initiatives using these guidelines as one of the references. This can be said to be a position that, rather than the government taking the lead in creating the rules through legislation, the first step is for all parties concerned to be fully aware of the problems of generative AI and to formulate rules through a soft law approach. So what is the situation in terms of the movement in the individual companies? In other countries, there is active movement, particularly in the media. For example, the BBC, the Guardians, Reuters, etc., have developed and published their own guidelines and policies. Although each has its own characteristics, they all have in common the following points. For example, the human supervision, transparency, provision of the information about the use of AI tools, limitation of the use, accountability over accuracy, protection of privacy, and etc., etc. Meanwhile, what about movements in Japan? Among Japanese media, the Nihon Keizai Shimbun, the published using AI in news reporting Nikkei thinks this way. In July last year, compared to other major Japanese newspapers, Nikkei is more active in the use of digital. The details can be found in these slides, but this thought is set out from the same perspective as that of foreign media, which specific situations to assist in editorial work, such as the extraction of data from reliable, publicly available information. In addition, an organization called the Japan Voice AI Learning Data Certification Service Organization has recently been established. This is very interesting action. This organization, in which voice actors, AI developers, and others participate, is attempting to make it possible to track the creation of voice AI services by assigning ID labels to training voices and training models created from the voices. This is an attempt to visualize whether the information has been created under license or not. The presumption that AI developers certified this association are good companies works to make it easier for companies to do business with them. For this reason, the organization's public interest presence is likely to grow as more voice actors and companies join in the future. It might become one of the core elements of soft law formation. This has been an introduction to the legislative approach with introducing to movements in Japan. Finally, I'd like to share my own brief conclusion from two perspectives, limitations and possibilities. The first, let me talk about the limitations. As we have seen, there are significant challenges with the legislation approach, and feasibility is not easy. In addition, technology is progressing extremely fast, and the legislation can not only keep up, but may soon become obsolete. In the case of Japan, it can be seen that, for the time being, a guideline-based soft law approach is being taken. And such an approach may have a certain rationale at this stage. However, the challenge remains that it is difficult to check whether actions are being taken in line with the guideline. So, what are the possibilities for the future? In conclusion, my view is that we should consider approaching the issue from a co-regulatory perspective, which is an intermediate form between government regulation and regulation by individual companies or individual entities. Specifically, the idea is to create a system in which a community of players meeting certain requirements takes the lead in rule-making and acts in accordance with those rules, thereby ensuring the effectiveness of the regulations, protecting rights holders, and returning benefits to right holders. The problem is the member of this community. One possible form would be to involve both right holders, such as voice actors and generated AI operators, as I mentioned already. I think this is one reasonable idea, but we may need to wait and see how well it works in practice. The other is that an existing copyright management organization takes on the core of the community. When setting up a new organization, it takes a certain amount of time and cost because it has to start by gathering the right holders. However, in the case of copyright management bodies, they already include a certain number of right holders associations in each field. And the fact that right holder in several fields are built in from the outset is also an advantage in terms of enhancing their bargaining power. Incidentally, in the case of JRRC, our organization, its members include the right holders associations for newspapers, magazines, literary artists, illustrators, photographers, and script writers. Another significance having a copyright management organization rather than a right holders association at the core is the latter has a great deal of knowledge about copyright business. This has great significance for the creation of a mechanism for returning compensation to right holders. However, it takes a lot of effort to establish rules for the distribution of the compensation. But the problem still exists, and it is still an advantage to have a copyright management organization which has a lot of experience and wisdom regarding distribution and play a central role. Now, of course, my idea is very crude, and there are many challenges in the practice, but in an age of rapid progress in digital technology, it is necessary to share an awareness of the issues with many colleagues from the board, medium to long-term perspective, and to work within with flexibility and mobility. So this is the end of my presentation. Thank you very much. Thank you very much for your attention.
Thank you, Takeshi. Due to time factors, we have 10 minutes left, and I'm going to ask 2 follow-up questions, so you're all free to respond. First, with regard to the licensing model that tries to, strike a balance between the AI technology development and the protection of right holders' interests. And I know that there is a recent announcement from the CMO in the US on the licensing model that is very pioneering and inspiring. So would any panelists like to share views on this?
I have views.
Thank you.
Look, I appreciate it's very late in the day and you've all just listened to a lot of legalese, so thank you for being here and thank you for your attention. But one thing that I wanted to highlight, and it's been sort of recurrent throughout the day that's made me slightly uncomfortable, is that there seems to be this sort of presentation of this kind of weird dichotomy which just doesn't exist in reality, that on one side there's creators' rights and on the other side there's innovation. That's a really false narrative, and it's a narrative that the tech companies, I think, have worked really hard to embed in us. I hope the room is full of creators and publishers, and I think we all know that we're innovative. I think we all know that we're agile. So it is, as to reiterate what Sam was saying earlier, it is absolutely possible to be pro-copyright and pro-AI. It is also very possible and actually very natural to be pro-creator innovation and pro-tech innovation. And to that point, to Sharon's question, I would highlight licensing solutions have existed in the market for decades, right? Unlike legislation, licensing solutions can be adapted very, very quickly to become very fit for purpose for AI needs. And indeed, we've seen the announcement from CCC, we've also seen announcements from CLA in the UK, we've also just yesterday seen another announcement from a UK organisation offering licensing solutions. We have RROs here in the Asia Pacific, copyright agencies looking to offer an AI licensing solution. JAC in Japan is about to start offering an AI licensing solution. Licensing solutions abound. They are everywhere, right? Numerous governments have also engaged very actively with AI companies to preserve their local cultures. So at the last year's General Assembly, we had the great honour of having the Icelandic president come and speak to us. And he was talking to us very openly about the negotiations his government has in place with OpenAI and various other tech companies to ensure that these tech companies aren't just training on English content, right? So governments are also negotiating and licensing content to AI companies. There's a similar project happening in Norway at the moment in combination with the National Library of Norway. The difference is when you have licensed content, the creators are getting paid, right? They're getting acknowledged. You have quality content that's being put into a system and the rights holders are being attributed and paid. That is very different from the modelling that has been presented to us from OpenAI and Google and so forth, where they have just trawled the internet and gotten illegal content and then presented this tool to us and said, look, it's already here, what are we going to do about it? Oops, we didn't know, okay? It's very disingenuous. The key thing that I want to point out here, and I'm sorry that I sound so, passionate about it, but the key thing to point out is that when tools like ChatGPT and Midjourney and DALL-E burst out into our markets, it was a classic example of that tech ethos of move fast and break things, right? It wasn't the case, it was absolutely not the case that tech companies had tried valiantly for months, years to negotiate licenses. They hadn't tried to get this content legally. They knew full well, there's a really interesting research coming out of lots of places, but there's a really interesting guy, Thomas Heldrup, who I encourage you all to look up. He runs an organisation out of Denmark that has done extensive research that really clearly demonstrates that Google, OpenAI, all these companies knew full well that the data sets that they were relying on included illegally pirated content. They knew what they were doing and they chose not to get it licensed. They know that licensing solutions exist because they've existed for well over 100 years. So to that question, Sharon, there was absolutely no example of market failure. There's been no market failure here. What we have here is disingenuous actors moving around, breaking stuff, and then presenting this thing to us and saying, oh, sorry, look, we did it already. What do you want us to do about it now? Okay? So that's, in short, my answer is that I think the evidence is very clear that licensing models exist and can evolve very quickly to be fit for purpose. Can I just say one more thing? I heard something really alarming at a conference recently, which is that tech companies have trawled the internet and they've gotten all the sort of moderately accessible data that they can scrape without paying for it. And now they need more data. So what are they doing? They are looking at synthetic data. Do you know what that means? It means that generative AI tools are creating their own data and then training themselves on their own rubbish data. Now, maybe if you're looking at a children's book, you don't mind so much if the sentence doesn't make a great deal of sense. But if you're looking about the applications, the potential applications for AI across medicine, health, climate change, like aeronautical engineering, I mean, it's terrifying to think that that's what's happening. So obviously, from IFRO's perspective, AI systems must be trained on legitimate, reliable, factually correct content, and licensing is the obvious solution to this. The key thing here is trying to convince the tech companies that they need to come to the negotiating table. That's where the problem lies. The license is not the problem. The problem is getting the people to the table that need to be at that table. Thank you.
Thank you, Sarah.
Can I just say, the other classic excuse that big data give is, oh, they can't track the data. Well, that's untrue. Even Grimes, who's an artist that some of you may know, has a business called Elf Tech, and she provides her music to anyone who wants to use it. She tags all that, so there's a person doing it, an individual, and 50% of the revenue goes back to her through a smart contract. So these things are entirely possible. Big tech are telling people that they can't be done, but there are standards out there already for the tagging of data that allow this to happen. So there's no technical reason for it not to happen.
Yeah, just to add in very quickly, I think don't suffer alone. Licensing may not be your primary business, may not be the thing that you do, but we have organizations like HKRLS, like CMOs like us, that work for you. So you can come to people like us to help you to negotiate license on your behalf. And we can go to these big tech companies to do the right thing. So I think do give us a call, your own local CMOs a call, and we can certainly help you with all these things.
Yes, I really echo this as well, because I think that, like for one of the arguments that the innovators are saying that it's just impossible inefficient to go out there and seek licenses from, all the copyright owners out there that's possibly available. But then, having CMOs and licensing bodies that are here to represent the copyright owners, it's really an efficient way, and it's a possible way to also cut down on the expenses in order for innovators to approach everybody as well. So I think it is a proper solution in order to be able to use copyright works in there. Because just thinking that if there's an organization that needs to obtain a license to do their day-to-day work, and we know that AI is soon to be the norm to facilitate, or we're going to use AI to do day-to-day work, then how come it would be fair that all of a sudden you don't need a license to do your day-to-day work through an AI platform? So it just doesn't make sense.
Thank you. So come to us. We have every different organization in different regions and countries. So I quickly turn to the second to last questions with regard to the recent change in legislations in Japan and Singapore, and proposed change in Hong Kong to follow suit. So regarding this recent change in legislation, so would any panelists share view on this topic?
Again, I have views. But someone else.
I love you.
Yeah, I think probably this might be a bit too early to predict what's going to happen, but I think a lot of the policies makers around the world are trying to play a wait-and-see attitude to see who is taking the first action, and if it works, and then we might follow suit. Saying that, I don't think Singapore or Japan has the best legislations around the world. Probably is the worst. Number one, number two ranked being the most open, right? So I don't know. I mean, personally, we are engaging the government a lot, talking to them. So hopefully, the thing is, it takes a long time to change policies and perceptions. So we try to seed our thinking. So hopefully in 2-3 years of time, when the new Copyright Act is coming along, they can take our considerations and make the changes when the time is right. Yeah.
Yes, and the current situation in Japan concerning the amendment of the law, the right holders bodies and the AI operators, they observe each other. And it's a very calm situation right now. But as you know, as Theresa-san, she presented at fair use in the UK and in the United States. Actually, 10 years ago, when I worked for the copyright division in Japan, a culture agency, there was a very huge issue introducing fair use article in the Japanese copyright law or not. And there were many lobbyists, their activities is very, very, were very active. So they really, they pushed out the government to amend the copyright to introduce the fair use article. But we protected from their, advocation, because Japan the system is very solid, very much different from the kind of United States law system, the jurisdictional system. And the next step from now on, as they have already presented, the best option is for me is to licensing, because the legislation amendment of the law is very, very difficult. So that is my conclusion. I'm sorry.
Okay. Thank you. I was told that the time is up. I'm like operating in a movie called Speed. So now I announced the roundtable ends. So thank you you all for coming to this IP roundtable. Yes, thank you.
Here comes to the end of the IP Roundtable. Once again, on behalf of HKTDC, I would like to thank our guest speakers and all of you for joining us today. 今天的圆桌会议已经完满结束，我仅代表香港贸发局感谢各位嘉宾以及在座的各位支持。Thank you very much. Wish everyone a fruitful visit at our HKTDC Hong Kong Book Fair. 祝大家在香港书展满载而归。谢谢。